Okay, so I'm Amy Dygert. I'm Director of Copyright Services. And Copyright Services is an office that's a joint effort between Council's office and the library. My office is in the library. And I'm going to talk about copyright and author rights for research and publishing. And so mine is going to be more substantive, more kind of teaching you the basics about copyright, because if you don't understand the basics of it, you can't understand the quandary that you get into with publishing and author rights and things of that nature. So copyright is a federal law, and like every piece of law that exists, it's in existence for a balancing purpose. So that's why we've got the scales there, and you see frequently when referring to law, the scales of justice, we're always weighing competing interests. So in copyright, we're weighing the right of authors on one hand to protect and monetize their work, and then on the other hand, we want the right of the public to access that knowledge so that we can advance society. But the question we also have is, what works are protected by copyright? So copyright protects fixed original creative works. And I stress creative because facts are not copyrightable. They're not creative, okay? However, you can have a historical document, a biography of somebody. You can have a work that is fact-based that is protected by copyright because there's a creative compilation or presentation of those facts. So getting back to our scale here, instead of referring to rights of authors to protect and monetize and rights of the public, blah, 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 to go through that, we simply refer to these things as exclusive rights, so the author's exclusive rights, and then limitations. So there are limitations on those author's exclusive rights. So a copyright owner has 6 exclusive rights, 5 of which we'll talk about here for a moment. The first is reproduction. So you have a right to reproduce your own work. In our sense, it's usually making physical or digital copies for colleagues, for students, for other people. You have the right to distribute your work. Again, usually digital copies, physical copies, etc. You have the right to publicly display and publicly perform your work. So often that comes about presentations at conferences, poster sessions, things like that. And then finally, you have the right to create derivatives. And that's very important because as you progress in your research careers, you are constantly going to be creating derivatives of your own work. Your work's not going to stay static. You're not going to start with, this piece of research and then that is the only thing you ever focus on in your careers as a researcher. It's going to evolve and build upon itself and maybe move here, move there, all being a derivative from the work that you did before. So the right to create derivatives is very important right for authors. So again, getting back to our balancing act here, that's all we need to talk about with exclusive rights. We're done with that. The rest of what we're going to talk about are limitations, and they get pretty heavy. So we're going to talk about these limitations from 2 perspectives. The first is from a research perspective, so you as students who want to use other individuals' copyrighted works in your own works, and then you as researchers and scholars who are going to be producing copyrightable works and might not want others to use your works. So we have 2 questions. If you put on your research hat, you're thinking, how can I use somebody else's copyrighted works? So there's 2 answers. You find a limitation, or you ask them for permission. If you put on your publishing hat, so you've just done research, you've written a paper, what are you going to do? You want to publish. You're wondering, how can other people use my work now? And so they're going to come to you to ask for permission. Or if you engage in a publishing agreement, you're going to get your work published, they will limit how you can use your own work. And we'll talk about that and how to try to prevent that from happening. So there are many types of limitations to the exclusive rights. Again, the exclusive rights, the copyright owner is the only one who has those rights. And now we're going to talk about how do we limit those rights? How can we get at those works? So there are statutory limitations and there are contractual limitations. So under the contractual category, there's the public domain. So most works, as we just discussed, if you have a work that's copyrighted, If you want to use somebody's copyrighted work, well, the work might be in the public domain. So generally speaking, all copyrighted works that were published before 1924 are in the public domain. So this is helpful, but then again, you know, it's almost 100 years ago, so some of those works aren't quite up to date. So if you're lucky, another area of public domain work are government works. And so if you're dealing with the sciences, you might be dealing with government agencies dealing with science that have published reports, data, photos, etc. All of those things are in the public domain, can be used without paying for them, without asking for permission, etc. Another statutory limitation to copyright is fair use. And how many of you have heard the term fair use by now? Should be most of you, I would expect. So fair use is a very common limitation used in scholarship and research. And what it does is you use a case-by-case analysis of the facts that you're dealing with to determine, is my use of somebody's copyrighted work, is that a fair use? Does the law give me protection so that I can use this without paying for access or having to ask permission? So at the Copyright Information Center, we've developed a fair use checklist. It looks like this, which I know it's shrunk down. The link is in there though, where we walk you through all these different factors that you have to consider to determine if your use is fair use or not. Now, our office cannot make a determination. No one can make a determination if your use is a fair use except for you. That's a very important rule on this campus. Even counsel's office, the lawyers on campus won't make a determination for you. They will have you walk through this analysis yourself. But we'll break it down here a little bit. So there's 4 factors to fair use. The first is the purpose and character of your use. So if you're using somebody's copyrighted work for educational purposes, nonprofit, transformative, so you're going to take it and put it into something else and interpret it or something like that, that weighs in favor of fair use. If the copyrighted work that you want to use is more factual, if it's published, those things weigh in favor of fair use. If you're not taking the whole piece, but just a little bit of it, just whatever is necessary to get your point across, you're not taking more than you need, that weighs in favor of fair use. And as long as what you're taking isn't going to supplant the market, so you're not taking away somebody's commercial livelihood on their work, that weighs in favor of fair use. And so if you look at these criteria and what, as a whole, weigh in favor of fair use, it's really the notion that I set out at the beginning, that we want to advance progress in society in the knowledge and the sharing of knowledge in society. So in contrast to the green bulleted points up here, if you've got somebody's piece of original artwork, some highly creative work that they've been storing in their basement, it's never seen the light of day, and you want to take it and put a picture of it on the cover of your magazine, that's not going to be fair use, because you're taking away that artist's right to commercialize their very creative works. But in contrast, probably a lot of the work that you would want to be using is probably fact-based. You're using it for nonprofit purposes, for education, for research. You're not trying to supplant the market or the commercial market. I just saw something pop up on there. Is that, should I be paying attention to those? Okay. So if you go through this analysis and that checklist that I showed you a moment ago, and you determine that your use is a fair use and it's fair for you to use it without seeking permission, then you don't seek permission. You don't ask the author, you don't reach out, you just cite it properly, use it, and move on with your life. So those were statutory limitations to copyright, which is to say they are written into law. The law gives you those rights around copyright. The following ones are contractual. So these are agreements between people. They're not written into the law, but they're agreements a copyright owner and a copyright user have between each other concerning how to use this information. And so the first one is academic agreements. So by virtue of being a student, you have entered into an agreement with Cornell regarding your copyrighted work or any copyrighted work you might enter or create while you're here. So at Cornell, students' work generally belongs to the students. You have a copyright into the work that you produce here for the most part. There are some exceptions if it's a work for hire, you've been given substantial use of university resources, if you're on a particular grant or a contract, but generally speaking, you own the copyrights in your work. There is an inventions policy, which would be part of Martin's office in his purview, and that trumps the copyright policy. So if you go and look on the website and look at Cornell policies, the inventions policy trumps the copyright policy. But one other thing to know is, aside from what the academic agreements are and the university policies are, you're most likely going to be working with a number of collaborators on these projects and on these works. And you should clarify the rights among collaborators. So if you're publishing a paper of your research with 3 or 4 other people, each of those authors and you should have an understanding of what your rights are. Who's going to reach out to publishers? Who's going to take the lead? Who's going to keep copies of the contracts, of the publishing agreements, and things of that nature? So another type of contractual limitation is a licensing agreement. And so, for example, Cornell University Library pays millions of dollars every year to subscribe to journals, right, and other materials that they have copyrighted materials within them. And so instead of you having to go negotiate with the publishers to get access to those works, the library has already done that on your behalf. So that is a licensing agreement that gives you access to copyrighted works. Creative Commons. Have any of you heard of Creative Commons or seen these symbols before? So Creative Commons works in a couple of ways here. Creative Commons is a private way to protect your work. So in most instances, it's people who say, I want to get my work out to a lot of people. I don't necessarily want a copyright or to register a copyright, but I want to have some say in how my work is being able to be used by other people. And so I'm not going to go to all of the different types of licenses in great detail. If you have questions, you can email me or talk to me later. But on the top left is the most basic type of license, which says you'll put that symbol on there and anyone can use your work. They just have to attribute it to you. But in between, you can restrict their ability to make derivatives. So maybe they can use your work, but they have to use it exactly how you presented it. Or you can say you can use it, but not for commercial purposes. You can't make any money off of it. You have to share it the way I did. So whatever restrictions of these 6 that you put on, somebody else has to do the same. So it's really a practical way. It's people trying to just be practical about, this is how I want to license my work. I want to make it easy and friendly for people to use it. And then another contractual limitation is a permission. So you might have somebody's copyrighted work that you want to use, and you might just send them an email and say, dear so-and-so, I read your work, it's titled this, I'd like to use it. And what you do is really, it's just that simple. You email them, you describe it, send them a link to it or a copy. You describe how you want to use it. It might be that you want to use somebody's graph or image describing their work or their research. Maybe you want to use that image in a poster session or in a presentation at a conference. You'd reach out to that person. You would say, this is how I want to use it, where, how many people would be in my audience. Can I have complimentary use of it? Can I use it for free? Hopefully they write back. Hopefully they say, sure, that's great. Just give me credit and that's it. But they can say no. They can request payment. Basically, you're entering into this private agreement, this license, and they can set the terms because it is their work. We have, in our office, there is a particular online learning course that we've been helping to do this process with for hundreds of documents and copyrighted works. And one of the courses in particular uses a lot of memes. And so we don't get a lot of response from the meme creators. We literally have to figure out who created this meme and email a meme creator and ask for permission to use their copyrighted work, because it is technically a copyrighted work. And they often don't respond to us. So you might not get responses. But if you're seeking permission like this, you should retain every attempt to get permission. Retain all the emails that you've sent that you get in response or don't get in response. Just because if a question pops up later on, then you have documentation for it. And then finally, but this is a big finally. Publishing agreements, okay? This is going to be very big for you. How many of you have published already? Oh, wow, a lot of you, okay. So how many of you read the publishing agreements that you signed before you published your work? And that's why I'm here. So how many of you retained those publishing agreements that you signed? You kept them? Okay. So when you go home tonight, look for them. I assume or hope that you kept them somewhere where you could refer to them. And look and see what they say. 99% or more of them will have said that you transferred your copyright to the publisher. And you no longer own the copyright, okay? Publishers typically want complete control over the works that they are going to publish. And so as a result, they'll want complete transfer of copyright, so they own it. They don't want you to be shopping your work around to other publications. So if they own it completely, you can't take it anywhere else, and no other publication can compete with them for your content. And they also often want to require you to pay for open access publishing. Did any of you do that? Pay some money to have open access publishing? A lot of them will, yes.
It's also just using a figure from the application.
I'm sorry, so.
Okay, so you publish this paper.
Yep.
In that journal.
Yep.
Which you will not be able to use figures from that publication in another.
You may not be able to. You would have to get permission from your original publication to use your own figure in another publication, another article in a different publication. And it happens frequently. And I've also encountered, again, this is why I say collaborate with your co-authors. I've had multiple faculty members who worked on a publication together. They had a publication agreement, and then one of the co-authors was asked by some other publication, oh, can you write something up quickly about that? And it was deemed to be a competing product to the original work. And so that's another reason why you have to retain your agreements, is to see what do the agreements say, what rights do you retain as the author, if any, and you have to sort out these contractual terms. But the result, a lot of times, is that if you're publishing and you just sign your work over, you technically, legally, might not be able to use your own work in the future, or in the classroom if you're teaching, in future publications. And if you remember, what's one of the exclusive rights to being a copyright owner? Derivative works. So if you're signing over all of your copyright, you are signing over your right to make derivative works. So you potentially could be prohibited from publishing derivative research based on your original research that was already published. So it could be pretty significant, and that's why you really have to look at these things. So these are some sample clauses. I'm not going to read everything, but the highlighted in red are some of the things that kind of make you wake up and say, oh, maybe I should read these things. One says that the publishing company has the right to alter your article to the extent necessary for its use. So they can change your work. Once you transfer the copyright, you have no right to it anymore. You don't own it, they do. They could change your work to whatever suits their needs. Usually it's for length or voice or something like that. But, you know, think about you as the researcher and the author of this work. If they're going to cut your article for length, I would think that you would want some say into what gets cut, because you know what's most important in your research and how you've presented it. The second one, you assign to the publisher all copyright, and all rights to use it in whole or in part. So again, they could cut it down. And all media of expression now known or later developed. And you give them the right to license or permit others to do it. So you give them the right to cut it down, do what they want with it. They can put it in any media, any language, anything from here on out for the rest of the time. And we have a website, a library guide about author rights that has a whole bunch more of these examples. We do also have examples of good clauses, so they do exist, just so you know. But some of these are just there to show you how severe the agreements can be that you're signing. So what do you do? Well, there's a number of resources you can use to help alleviate any problems with transferring your copyright. So first of all, we have a website that I'll show you that's called Sherpa Romeo. And it's a tool you can use among a number of tools to look at what publishers' policies are. And so this is what it looks like if you go to Sherpa Romeo. And that box over on the left corner, you'd enter into it the name of the journal you want to publish in, or you want to target to publish in. And when you're done with that, press enter, and this report comes up. And what this website does is it looks at all of the different copyright policies and publishing policies of each journal and tells you basically the highlights and the lowlights of what you need to know as a researcher. So this one, for example, the Journal of Nutrition. You get to the main part and they tell you what you can and can't do. So for example, publisher's version PDF, you can't post that. So if you get published somewhere, your inclination might be to get a PDF of that publication, right, with your work because you've made it, you're right, you've been published, and put that on your website or send it to people. With this journal, most of them, you can't do that. You're prohibited from doing that. And if you do that, you're actually violating the terms of your agreement with the company, with the publisher. You know, there are other things. Most of them you can put them on your institutional repository, like archive or whatnot, but there's an embargo period. You can't do it for 12 months or 24 months or 36 months. So I'm not saying that all these things are bad, but they're things to be aware of. Because most people just sign, publish, get excited they've been published, and they share their work everywhere without realizing what the rules are. And in fact, about 5 years ago, maybe, over winter break, Elsevier, one of the big publishers, sent takedown notices to researchers all around the world because those researchers, none of them read their publishing agreements. They all had the publisher PDF copy of their work on their websites, on their institutions' websites, etc., all in violation of their agreements. So they got takedown notices like at the beginning of winter break. Of course, no one's around, so they don't read it. And then further action is taken because nobody does anything about it for the month that they're gone. So it's important that people read what their agreements are so that they can follow the rules, not get in trouble, and so that you can retain some of your rights to do your research. So Sherpa Romeo is a guide only. It's one tool that you can use when you're considering publishing. So one thing that we like to say is you're going to use that, but you're going to need to look at your agreement because your agreement rules. Your agreement is the actual contract. But before you sign and return your agreement, what you'll want to do, most likely, is to look at a Spark addendum. And so this is a PDF of what it looks like, the Spark author publication agreement. And I'm going to flip to the next page where I've pulled out the language to see it. What it does is it's an agreement that is an addendum to your publishing agreement. So they go together. And what it says is basically, no matter what the author agreement is, the publishing agreement is that I sign with the company, with the publisher, this agreement is now part of it. And if you look at the language in blue, it says, I, as the author, retain certain rights. I retain the right to reproduce, to distribute, publicly perform, publicly display, in any medium for non-commercial purposes. So this is retaining all those exclusive rights you as an author signed away probably when you sign publishing agreements. This is helping you retain those things for non-commercial purposes. So you're not trying to compete with the publisher, but you're trying to retain your own rights to advance your own research and scholarship in the future. The second bullet, you have the right to prepare derivative works from the article. Obviously important as your career advances. The third item, you have the right to authorize others to make any non-commercial use of the articles. So especially if you're in academia, you're giving your colleagues, your faculty colleagues, the right to use your work in their classroom as a teaching tool. And then at the bottom, it says that explicitly. For example, author may make and distribute copies in the course of teaching and research, may post the article on personal or institutional websites, and in other open access digital repositories. So this addendum is really intended to just preserve the rights you need as a researcher and scholar moving forward in your young careers. Right, so So really what you should do is you should have, have an idea of where you want to publish, look up what their policies are. Don't just submit and click through and say, yep, I accept. You need to have this signed before that, okay? And the reason is, if you sign their publishing agreement and then try to do this, they have no incentive. You've already agreed to publish, they're done, they don't need this. So you do this first, and you get them to sign off on this first, saying they agree to let you retain your rights. And so once they've signed this and you've signed this, then you sign their publishing agreement. This becomes part of it. They get what they need. You get to keep your work for non-commercial purposes for research and scholarship. Yep.
But is it true though that the publisher has the right not to want to publish their work if they don't agree with it?
Yes. It's not likely, and I've never heard of it happening. So you have. Okay. I've not heard of it happening. In fact, what I've heard is they may say, we don't want to sign this, but they may say, we don't want to sign this, but they won't say, we're not taking your paper now. And I don't know if that's.
It was hearsay, but I've just heard stories.
Yeah. This is becoming more and more popular. And really it's because the publishing industry has undergone a revolution as we've had this technical revolution over the past 10, 20 years. The publishing models have changed. It used to be we publish in a paper publication and it gets mailed out and that's it. But publishing companies can do so much more work, so much more with your work now because of the electronic age that we live in. So they have more things they can do with your work. And so they want to limit what you do with your work so they have complete ownership and they can invest in your work in all these different markets and whatnot. So this is the academic world, the research world, trying to take some of the power back and trying to equal things out a little bit, even things out a little bit. Again, restoring that balance, which copyright law is all about. So again, understand and manage your rights as an author. Use a number of tools. Use that website, Sherpa Romeo. Look at your publication agreement. Look at the publisher's website. Look at our LibGuide that we have that's linked to in here. And look at the author's rights addendum. But more than that, stay in touch with my office, reach out to my office, because we often look at copyright publication agreements. And we'll say, all right, you've got this agreement, you haven't signed it yet, that's good. It's letting you keep this right, or it's making you give away this right. You need the author addendum, or you don't need the author addendum. But I'm a lawyer. The person who works with me doing copyright is not a lawyer, but he's worked for publishers for a number of years before coming to this role. So we're very familiar with these agreements and how to read them. And we're just an extra resource to help you navigate this process. So don't be afraid to reach out to us if you have questions. And again, this whole session, are you making these slides available to everyone? Okay, so these slides are here. I don't expect people to walk away from this memorizing this, but just to plant the seed that this is an issue and our office is a resource for you if you have questions about this in the future. So really, in conclusion, use public domain works when you can. You know, there's a number of ways in which you can use other people's works, and then there are ways in which you can protect your own work, particularly with the Spark Author Addendum. And you can always consult with my office if you have any questions, have any needs, things of that nature. Any other questions?
If I don't have the right to post a PDF of my published work, but I did post it anyway, what's the punishment?
So it depends on the publisher. So you should probably, if you don't have the right, if your publishing agreement says you don't have that right, you should take it down. And they'll tell you what you can put up. Usually it's a pre-refereed version. So a PDF type version of your own work, just not their pagination and things like that. But it depends on the publisher. Some of them will just be nice and send you if and when they realize, they'll send you a takedown notice to say you have to take that down. They might say, if you want to keep it up, that's fine, but you have to pay us a licensing fee because we own your copyrighted work and you want to use it. So now you have to pay us.
You just put a link to the paper?
Yeah, links are great. Links don't infringe on copyright, so you can always link. And actually, a lot of them, I don't know if it shows it in here. No, but some of the, like the general conditions section in here, a lot of them will say you can put your preprint on there with a link and a DOI to us. They actually want you to link to them so they're getting the traffic to their websites. They just don't want you to, because if you put up their version, then you're alleviating the need to go to their website and drive traffic.
Other questions?
As far as I understood, it's not possible to send an email to your work to other colleagues.
Right. I mean, it depends, again, on the agreement you signed and what the restrictions are, but generally speaking, I would say that's probably correct.
So it's not possible to send any other work, other colleagues, other authors to email if the publisher doesn't allow.
If the publisher doesn't allow it, correct.
Would you say most of the big publishers like Wiley, Springer, Elsevier are accepting of the Spark agreement?
I would say so, and they're increasingly accepting of it because people in my position are going out and educating, and so there's more resistance on our side, on the academic and the research side, to just signing away the rights and walking away.
It's a big question. How often is this sort of thing for on the website? So you have one case with Elsevier and now that is
I don't have numbers or statistics. I can tell you when that individual Elsevier thing happened a few years ago, it was huge. It was, you know, you say it's one instance, but it was one instance with, say, 10, 20, 50,000 people. Yeah, but all of the big publishers are looking at this stuff. You know, it's a matter of how much you publicize what you're doing with it, where it is, you know, if you're going out and presenting a lot, because most of these publishers also go to conferences, right? Because they're trying to talk to people to pick up works. So if you're presenting there and you're saying, oh, it's on my institutional repository or it's on my website, they're there, they're being made aware. So, you know, it does have somewhat to do with how much you publicize that you've got it out there. All right, thank you.